Thank you very much, and thank you, Chair, for the opportunity to join. I'm interested in respect of, first of all, you mentioned, I think, many occasions that there's more and more regulation all the time and that there's still lots of trade agreements. But of course, what we've also seen is, as there is more and more regulation, particularly in the area of the environment, there are more and more cases being taken by investors for compensation in relation to that investment. So 80% of such investor claims as have been taken in the last 15 years, and that number has increased year on year. So I would say, yes, indeed, as we have more regulation, there is a relevant factor, which is where regulation is occurring, we are seeing more cases taken, and particularly in the environmental area. And that's something been acknowledged by the EU Commission in respect of the Energy Charter. I'm also very aware that when we talk about risk analysis, I was quite surprised. I mean, I've been on the board of a very small company and we conduct a risk analysis. I mean, yes, of course it is about imagining scenarios. And the idea, I would say, frankly, that the Department of Enterprise hasn't conducted a risk analysis is, I think, a cause for concern for everybody. And for example, what might be considered in that is the risk analysis in terms of what the legal cost might be, an area indicated, because we know, for example, even in the infamous Philip Morris case, where Australia won the case, that it was a €12 million legal fee for Australia in that regard, even though they won the case. And again, when we talked about that decency principle, the fact is countries do pay very large costs even when they win. But also in terms of a risk analysis, the risk analysis in terms of areas of policy whereby we may have exposed ourselves already. Because one of the grounds for fair and equitable treatment, or a claim of unfair and inequitable treatment, is under 810(2) of the CETA, where representations have been made to investors to induce investment, leading them to have a legitimate expectation of operating in a particular area. I mean, a very clear example might be, for example, the REITs who've been encouraged to invest in a certain way in property, or many of the others who've been encouraged or supported. And again, what's regarded as encouragement or inducement in case law under ISDS is often as simple as giving planning permission, maybe giving a grant, a meeting with a representative body of the state. These may be regarded as giving legitimate expectation and then creating a vulnerability when regulations in that area are changed to a claim for compensation. And we need to be really clear. Nobody's talking about whether or not the state can regulate. That's not the question. The question is, when the state regulates, is there a potential liability that is added by this investor court system for compensation in respect of companies who feel that they have been unfairly or inequitably treated? And Minister, you've indicated that we don't have to worry because we won't discriminate. Are you then telling us that all policies in these areas where there are investors from Canada will be examined, and that we will ensure that we form those policies in a way which will not leave us vulnerable to cases being taken? That's a kind of a clear question. Like, is that why you were confident we won't discriminate? Is it because you've done a full review in relation to our exposure to investors, such things we have done that may constitute inducement? I'd also just really like to talk about the fact that cases increasingly, yes, it is the case that there are arbitration mechanisms in all trade deals, but it is the case that in many cases, increasingly, those arbitration mechanisms are between solely the parties. So the countries are blocks of countries, not private investors. In the UK-EU deal, there's arbitration between the UK and the EU. In the new deal in Canada, between Canada, the United States and Mexico, there is a very limited access for investors, the arbitration between members. And one of the reasons I would argue for this is because of internationalism, because there's an increasing realization that those shared international goals that Europe shares with Canada around climate, that we share around sustainability and so forth, could potentially be undermined when an individual company that doesn't have to share those values decides to take a case in respect of its interests. So in that context, are you concerned that there may be diplomatic or international damage if an Irish company were, for example, to sue Canada for taking an action that damaged that company's interests and perhaps the company felt was unfair, but which were in line with our collective international goals in the area, such as climate. Thank you very much.
Okay, Senator. I think you might be able to dig out a couple of questions there, Tánaiste. I know, and thank you for
explicitly around discrimination, explicitly around what mechanisms will be in place to anticipate and look at questions about whether there might be discrimination, and also what financial risk assessments might be taken.
Yeah, thanks. Thanks, Senator. I think one of the points you make is very, very valid. That there are more and more cases being taken with respect to environmental regulations all the time, and indeed other regulations, not just by companies but also by NGOs. But people and NGOs and companies have the right to sue. The question is, are they successful or not? In terms of the risk analysis, it is as I described it, and we can write that up if you like. But essentially what we're saying is that the risk is minimal to zero. It's never possible to know for sure, because it's impossible to imagine every scenario. But because of the reasons I explained, we would believe that the risk is minimal to zero, but we can certainly write that up.
So just to clarify, I was actually asking about what the process will be to assess whether or not there is a risk of a case being taken for unfair and inequitable treatment in respect of a policy. And I would just point out in relation to the NGOs and companies, of course, in our courts, everybody can take a case. In the case of this, it is only companies that can take a case. And I would notice there seems to be a bit of a contrast whereby in the climate bill, there's an explicit clause limiting liability in relation to inaction on environmental matters, or inaction on environment, limiting financial liability in that respect. Yet at the same time, we're proposing to bring in a new financial liability in respect of CETA. So we're actually treating NGOs and companies quite differently. We're trying to take financial leverage from one and give it to the other.
Yeah, I think they're very different issues, and that's a little bit disingenuous. This would be a scenario whereby an investor actually was discriminated against and lost out. An NGO claiming losses on behalf of somebody else or society in general is very different to a legal entity like a company, or even an individual claiming that they incurred losses themselves. But just to answer one of your earlier questions, you asked, is there a risk of the state being sued if the state were to change its regulations or its rules midstream?
I asked what the process will be to assess whether or not there is a risk in relation to new areas of policy, new legislation. Consideration process.
I'm not sure, to be honest, what the process would be, but is there a risk? Of course there is. So if the state or a government changes its regulations or rules midstream, can they be sued? Of course they can. They have been. The state is sued from time to time when it changes its rules or changes regulations midstream or mid-process. But is that risk higher because of an ICS? I don't think so, because the same company or the same entity could take the state to the national court. So is there a higher risk? I don't think so, no.
I think the financial, maybe just one last question. Would you not agree that the fact that in a national court, a court is required to interpret other aspects of the law to balance, for example, environmental law against the financial concerns or the sought for compensation, whereas an investor arbitration board is, as you've described very eloquently, solely concerned with the compensation question. So in that regard, it is a very different, and that is why companies go for investor courts, because investor courts, in fact, will not be considering, the rights of the child or whatever other considerations a national court would be balancing in determining an outcome in that regard. So I think it is, but just you mentioned midstream, a very last thing on that. You mentioned that companies make 30-year investments. I mean, would you be suggesting that when a company has made a 20-year or a 30-year investment based on certain expectations, if that policy if a state policy in that area gets changed within that 20 or 30 years, is that the state changing policy midstream? Because I would be very concerned that we may be tied in that regard to the expectations that a company had at its point of investment.
Yeah, no, I think there's two things there. I think one point you're missing is that it has to be discriminatory. It's not the case of the government or a state changing its rules or bringing in new public health restrictions or new environmental laws. The company would have to prove that they had been specifically discriminated.
Well, actually, they have to simply prove that that they were treated unfairly or inequitably. So discriminatory is only one part of that criteria. In fact, unfair and inequitable treatment is a movable feast. It can, in fact, be changed under CETA and new elements can be added to it. But one of the areas which is specifically there in Article 8.10.2 is that in deciding whether a company has been unfairly or inequitably treated, is that question of inducements. If you could just comment on that question of, have you analysed whether state planning permissions, state investment, as we've learned in some areas, state meetings with representative bodies and other such state encouragements for companies to invest may be constituted as having given reasonable expectation. That's part of the risk analysis.
Okay, before the Tánaiste comes back in, Senator, look, you've come back in there and asked the question in different ways. Can you let the Tánaiste respond and give them the space to respond? Because there's a number of people with supplementary questions as well. So
I will not intervene again. Thank you.
Thank you. Thanks, Senator.
Thanks. Thanks very, very much, Senator. I think just to be very clear, it's always open to states and should always be open to states and democracies to change their rules, regulations, if they believe it's in the public interest to do so, and have been a member of 3 governments and have done that regularly. Notwithstanding that, of course, a policy certainty is good for business, and if you're making a long-term investment, you want to be aware of that. So anytime we do change the rules, if you like, we have to take into account the effect of that, and we have to balance those considerations. But I think it might be helpful just to state what's actually there in the agreement, and it's very clear in my mind. It says here, a party breaches the obligation of fair and equitable treatment if a measure or series of measures constitutes a denial of justice in criminal, civil or administrative proceedings, or B, a fundamental breach of due process, including a fundamental breach of transparency in judicial and administrative proceedings. So that's a very high bar, I think, that a company has to get over to prove that they've been mistreated. And again, it says in the agreement for certainty, the mere fact that a party regulates, including through a modification of its laws, in a manner which negatively affects an investment or interferes with an investor's expectations, including its expectations of profits, does not amount to a breach of an obligation under this section. So I think they're very clear protections, and it's a very high bar for companies.